let's talk about the federal appeals courts. First, a few words about the structure of the federal appellate system. There are some federal courts with appeals in the name that are not commonly known, such as the Court of Appeals for the Armed Forces and the United States Court of Appeals for Veterans Claims. But the most common federal appeals courts include the 11 numbered circuits and the D.C. Circuit. These are all geographically defined. And the United States Court of Appeals for the Federal Circuit, which has nationwide jurisdiction over certain appeals based on their subject matter, most notably patent cases and appeals from the Court of Federal Claims. Let's now talk about the appeals process. So, cases only go to appeals courts because one or both of the parties in the lower trial court is somehow unhappy with how the trial court decided things. The party appealing the case is the appellant. The party responding to the appeal is the appellee. The next thing to know about the federal courts is that only certain trial decisions can be appealed. In civil cases, the general rule is that parties may only appeal a final order on the merits from the trial court. So a final order is an order that gives a final determination on the disputed issues in the case. For example, a judgment for a plaintiff after a jury trial would be a final order. An order granting summary judgment and dismissing the plaintiff's claims would also be a final order, because both of these orders basically finish the trial litigation and make the case ripe for an appeal. There are a few exceptions where a party can appeal before a final order is entered in a civil case. This is called an interim or interlocutory appeal. These situations allow a party to appeal even though the case is not over in the trial court. But interlocutory appeals are only rarely granted, and only in very specific situations. For example, some types of trial orders, such as injunctions, are automatically appealable as an interlocutory appeal. Trial judges can also certify important legal questions for an early appeal, and certain other decisions are potentially appealable, such as decisions on class actions. In a criminal case, the defendant can appeal a guilty verdict, but the government cannot generally appeal if a defendant is found not guilty. If the prosecutor wants to appeal a general trial decision, it must often ask permission from the government before it can do so. Another important aspect of appellate courts is they consider only a narrow set of issues. In the trial courts, parties constantly argue about a number of legal and factual issues. But the issues decided by appellate courts are much more narrowly confined. First, appeals courts only consider issues properly raised in the trial court. For example, where a party specifically objected to a trial court decision before or during the trial. Second, appeals courts only consider issues actually raised for appeal. Appellate courts generally ignore issues raised for the first time later after the appeal has been filed, such as during the oral argument phase. One of the most important concepts to understand about appellate courts is that when the appellate court reviews a lower court's decision, it often gives deference or some benefit of the doubt to the lower court. This concept is called the standard of review. A different standard of review may apply in any given case. The standard of review that applies depends on what type of lower court decision the appeals court is reviewing. Some of the most common standards of review include clear error, substantial evidence, de novo, and abuse of discretion. The standard of review is absolutely crucial to understanding the appeals process. The standard of review that applies completely changes how the appellate court looks at the trial court's decision and how it decides whether that trial court decision was correct. So let's talk about these common standards. The clear error standard is a highly deferential standard and used when reviewing trial court decisions about what facts to believe, such as whether a witness's story was true. Appellate courts rarely overturn trial court decisions on clear error standard. The substantial evidence standard is another deferential standard for findings of fact, where the appellate court asks whether there is at least substantial evidence to support a factual or legal decision below. The abuse of discretion is perhaps the most deferential standard and is employed when reviewing decisions that are left to the discretion of the trial courts, such as the decision to sanction a party. Appellate courts very rarely overturn trial court decisions under the standard. And usually, if an abuse of discretion standard is applied and the trial court is reversed, it's because the trial court did something outrageous, typically in the process in reaching their decision. Finally, the de novo standard is a totally non-deferential standard of review. It's used when reviewing questions of law, such as where a trial court has decided the meaning of a statute. Virtually no deference to the lower court is given whatsoever, and appellate courts frequently overturn lower courts on the de novo standard. So let's next talk about the appeals timeline. First, to start an appeal, a party must file a notice of appeal within a certain number of days after the lower court decision that's being appealed. Next, the parties prepare the record of all relevant documents the appeals court will need to review the case, leaving out any documents irrelevant to the issues that the parties raise on appeal. The parties then file their briefs, explaining how the lower court got any legal decisions or factual findings wrong. The appeals court then decides whether to allow the parties to make oral argument on the briefs. Finally, the appeals court deliberates and prepares an opinion. They decide who should win on the various issues raised on appeal. Appeals are usually decided by panels of 3 judges working together. In some cases, the decision may be reviewed en banc, that is, by the full group of judges. After the appellate court makes its decision, either party may then file a petition for rehearing, attempting to persuade the appellate judge that the appellate judge somehow got it wrong. The Court of Appeals decision usually will be the last word in a case, unless the parties want to roll the dice and try for review by the U.S. Supreme Court, who considers only a very small number of cases each year. This should give you a general understanding of how the federal appeals courts work.